request to all participants to self-mute themselves, but even the host can maybe disable audio of the participant so that we don't get disrupted. So I was saying the nice thing about this profession is that the regulations have been so very dynamic. As and when needed, they have been tweaked. They've been with the requirements of the profession. One can see the several amendments which have been there over time in both the code and the regulations. And today we are going to discuss what could potentially be done in terms of resolving the situation of liquidations. Liquidation is the terminal outcome of any entity. Liquidation can never be the objective. As has time and again been stressed by the Supreme Court also, liquidation is the last resort. That's the terminal stage of existence of any corporate. The objective basically is to resolve. The objective is to maximize value, and liquidation is only the fait accompli should the attempt to resolve or revive the business fail completely. And therefore, it can never be the objective of any insolvency system to aim at liquidation. Liquidation is therefore never aimed at. It's something which invariably happens as a fait accompli. But should liquidation commence, I mean, that's not the desirable states, nevertheless, but should it commence, then the combined effort of both the insolvency professional as also all stakeholders in the liquidation process is that number one, liquidation is resolved efficiently in terms of time efficiency. It should be resolved soonest. And number two, it should also result into value realization. Here, the value is mostly by way of value realization, whether sale by way of a going concern or sale in terms of piecemeal sale of assets or sale in terms of, let's say, slum sale of assets. But there should be efficient liquidation of assets as also timely realization and distribution of the realization proceeds to all the stakeholders. Over time, very complicated issues continue to arise. Some of these issues were not noticed earlier. Over time, let's say with developing jurisprudence of courts, number of new issues are emerging. For example, lately, I'm sure other liquidators must also have the same experience that lately sales tax officers, particularly from Gujarat, have been serving notices on liquidators to treat the tax dues at par with dues of secured creditors. Obviously, that's based on rulings of Supreme Court saying that tax dues are taken to or are assumed or deemed to be secured creditors because there's a deemed security interest by virtue of a statutory provision. It's a statutory charge and not a contractual charge. And even though the charge is statutory, it ranks at par with secured creditors. Now, obviously, the tax officers from the states wouldn't have filed a security interest. They wouldn't actually have a ROC registered charge. They wouldn't have done Sarsai filing as well. Nevertheless, when they file the claim also, they wouldn't have probably given the particulars of security interest, because in terms of claim filing also, when the claim is filed, the particulars of security interest must be given in the claim form. So there are various issues that come, even if one were to go by the Supreme Court ruling, treating the tax dues at par with secured creditors, many issues come there as well. Also, it's never been settled as to what is the treatment of certain part of workmen's dues. For example, a shortfall in gratuity contributions. Now, while the matters are still pending adjudication by Supreme Court, but currently there's a confusion on what happens on shortfalls of gratuity contributions or shortfalls of PF contributions or shortfalls of interest on PF arrears, etc. Many of these issues continue to come, and each of these issues, some of these issues might require a regulatory change. Some of these issues might require a legislative change, actually, the change in code. Now, here today, our objective may be to discuss the liquidation regulations. I'm not sure to what extent can we get into fundamental issues of lawmaking. Lawmaking is not the domain of IBBA. Of course, lawmaking becomes the domain of the government. And lately, there was an MCA discussion paper where we had discussion on the proposed amendments from MCA itself, which is potentially likely to be probably leading to a statutory amendment, which might probably see the light of the day in the forthcoming monsoon session. That's something that we'll all watch out for. But whenever we talk about issues in liquidation regulations, the issues could be mixed issues, both involving regulation as also the code. Now, I'm not sure if it would be strictly possible to limit ourselves to only those things which require regulatory changes and may not result into change in the code itself. So even if, based on discussion today, there are some issues which might go towards the code, I'm hoping that maybe the issues can be flagged still for onward submission to ICSA IPA for them to consider whether to, bring it to the notice of IBBI, and later can probably then take it up if at all there's a statutory amendment required, may potentially be considered. So what we have done for making a structured discussion here, while all of you are completely free to point out your own experiences, but we have identified some potential areas which might require discussion here. And number one, starting from collation and verification of claims, and that's something that takes time for everyone. Constitution and role of the stakeholders consultation committee will probably, that's mostly the product of the regulation. Stakeholder consultation committee was not envisaged in the law itself. It came later by way of changes in the code. And over time, the constitution of the SEC, the voting powers in the SEC, have continued to evolve by regulatory changes. Now, what's been the experience of the House? What's been the experience of liquidators present here on the way the SECs have worked? That's also something that we would like to hear views and then maybe have a collaborative discussion to take points for further reforms of the regulation, perhaps take it across to ICCI IP and thereon maybe to IBPI. Treatment of workmen dues and employee benefit funds I talked about earlier. Treatment of avoidance transactions, particularly what happens when liquidation proceedings come to a close, but the avoidance proceedings is still going on. That's something that I'm sure many of you might have faced. The matters of avoidance transactions, section 43, 45 onwards, these are adversary proceedings. You are filing a case against someone, and that someone mostly would be a promoter or some other, let's say, connected party. And there is a stiff resistance that these parties would probably have that try to agitate these matters in NCLTs for a long time. Liquidation comes to an end, but the avoidance proceedings still continue to go on. So what happens to pending avoidance transactions, avoidance proceedings? Who bears the cost? Who agrees to pursue, etc., are matters that need to be discussed. The priorities of secured creditors, particularly with reference to state government dues, that's an important point that has started emerging, which is what we're seeing in terms of tax dues as well. Terms and conditions of sale, particularly the way you structure the auctions, methodology of auction. Does it always have to be with a disclosed reserve price, or can we do auctions with a blind reserve price as well? Idea basically would be to intensify the competition, because the experience shows that if there are more parties competing, then the value maximization does happen. So can there be ways by which participation in auctions can become more meaningful? That's first condition. Number two, the conditions of sale. For example, the earnest money deposits, the payments that you get in addition to the EMD, forfeiture of EMD. These are points which are not exactly very clear in the regulations, and therefore they might need regulatory clarity once again. Sharing of reports and documents to stakeholders. One continues to get requests for sharing of this report and that report from various stakeholders. So much so that even lay shareholders, ordinary shareholders also keep writing to liquidator, share me this report or share me that report. So the question is, are you required to share reports with almost every stakeholder, including a shareholder? And if yes, then subject to what conditions? And there are other issues which are more in nature of, let's say, there might be some apparent, what do you call, conflicts in the wording of the regulations itself, which might also need a little flagging here. So I'll just quickly talk about one particular point as to why this discussion is so very important, and then hand over to my colleague Barsha, would probably steer the rest of the proceedings. As far as the timelines of liquidation are concerned, the targeted timeline has been quite ambitious. The code expects us to complete liquidation within just 1 year. Originally 2 years, later on reduced to 1 year. The reality, however, so far has been quite, I would say, different from this expectation of the lawmaker. As the slide shows, more than 55% of liquidation proceedings as of now, as on 31st March 2023, have been pending for over 2 years. Therefore, the expected timeline of 2 years is seen more in breach than in compliance. And I don't think we have data for more than 3 years, more than 4 years, or more than 5 years as well. But I'm sure there are proceedings which are outstanding for more than 5 years. And there are probably several of them. And the question quite often comes, why are they pending? Well, mostly they're pending because there is pending litigation. So while there are timelines for liquidators, do we have timelines for the adjudicating bodies as well? This is a little tough question. The moment you try to raise this question, the answer is you don't know the infrastructural difficulties that the adjudicating authorities and NCLTs face. For that matter, I don't know who bothers about the infrastructural bottlenecks that the insolvency professionals face. If I have not been able to do something in time, can I lay it on my infrastructural issues? Can I say my infra was missing or my infra was lacking or my colleagues were not able to attend office for whatever reason? No, I cannot have those defenses when it comes to timelines for me. Therefore, every player in the ecosystem has to meet up with the timeline set for the ecosystem. And to say one agency will keep meeting timelines, not the others, I think that ultimately doesn't help, because it has to be a combined work of all the agencies in the ecosystem. And so that's exactly why we need to talk about timelines and talk about the need for making liquidation regulations more efficient. Let me with this, we talked about therefore roughly about 10 issues that we have flagged for discussion today. But all of you are practitioners, all of you have your own experiences. Kindly feel free to share your experiences in order to keep this discussion focused and structured and not to result into, too much of digression here and there. We'd probably like to stay structured on this presentation. Later on, if there are issues which are in addition to what has been flagged here, maybe all of you can contribute. So my colleague Barsha will take over from here and start from the first issue that we flagged is acceptance of claims. The issue that we're trying to say here is that a lot of claims come with delay, particularly claims from the government. Some of the claims have been coming after 4 years, 5 years, etc. And these claims, the statutory timelines are, of course, 30 days only. And these matters go to the adjudicating bodies. The adjudicating bodies typically condone the delay. So is it, if it's just a technical condonation of delay which happens in NCLTs, is it something which the liquidator himself can probably do instead of mounting litigation? Or should there be a hard timeline after which even the adjudicating body shouldn't be extending timelines? So Barsha, why don't you just take over from here? I would just have to add one particular point, and I will be obliged if people can share their experiences, because a lot of you might have experience on this. The working of the stakeholder consultation committee. Like I mentioned before, that SCC or any kind of consultation committee for that matter was not originally envisaged in the code. It was added by way of regulations later. While inclusiveness, accountability, answerability of liquidator, that's definitely a very important consideration, that liquidator cannot be acting without anyone to report to, without anyone to be accountable for. After all, the liquidator is working on at the behest of the creditors. Creditors are the stakeholders, and therefore liquidators must be answerable to creditors. But liquidators functioning directly under the control, so-called control of the SCC, where even procedural matters, for example, appointment of valuers or appointment of professionals, these matters also go to an SCC, which is once again a multidimensional body. Unlike the COC in resolution, which is consisting of all creditors. And remember, creditors typically have the same mindset because all of them are mostly bankers. But the moment we move to SCC, we're talking about a multi-dimensional body. We're talking about from workmen to shareholders to creditors to operational creditors, etc. People with completely diverse interests, diverse priorities, they coming together and taking a collective call on the liquidator's functioning. How does it help? How does it deter the working of the liquidator? Possibly, this is a very important point which might probably require discussion of the house. So Barsha, if you can maybe take over, and I don't know if it's possible to maybe schedule it to start this discussion first, have the views of people on the way SCCs have been working, and then maybe come to the claim part. So Barsha, would you like to show up and take it from here? Maybe start with SCC first.
Yes, sir. I'll share my slides, sir. I think that will be convenient for both of us.
Perfect. So maybe start with the SCC part, hear people's experiences,
Right.
and then I think we can go back to the claims part.
Right. I hope my screen is visible to all.
It is visible.
Good evening, everybody. So the agenda today basically is to discuss about the
Good evening, ma'am.
So the agenda today basically is to discuss about the potential areas of regulation, liquidation regulation that requires amendment or that requires necessary changes based on the practical experience that we as an insolvency professional are facing, and to note down the same so that the necessary changes can be done by the regulatory authorities in the respective areas that requires attention. So as sir has said that we have dotted down some of the potential areas that in our view requires attention. However, there may be some other areas as well. So given that the very agenda behind this webinar, I'll request all the participants to be participative, provide their views as to what they think, if they have some other views, or if they think that this area should also be highlighted. So the views are welcome. So I'll start from the stakeholder consultation committee part. Currently, Regulation 31A of this liquidation regulation provides for stakeholder consultation committee. Forming of the stakeholder committee as to who all should be a part of the stakeholder consultation committee. And then what will be the voting right of the respective members of the stakeholder consultation committee, who all should be there in the stakeholder consultation committee. Now, the regulation also requires participative right to the respective directors, shareholders, and promoters. However, voting right is not there. There is a lacuna in the regulation that in Regulation 31A2, while it is mentioned that the promoters, directors, etc., will have participative right, but will not have the voting rights. However, in subsequent regulation, it is provided that voting shares will be in terms of their contribution. So the first thing, the concern which is here is that decision making is directly related to the incentive of the decision. Should a creditor, like operational creditor, government claims, employees, etc., with a very little chance of any realization, should also be a part, or is there any meaning of making them a part of the stakeholder consultation committee at all? Then second, is stakeholder consultation committee, is the powers of stakeholder committee should be limited to advisory or should be decision making as well, given that the current position or the voting rights or the voting powers which are provided in the current regulation, it seems that the idea behind this stakeholder consultation committee is moving from advisory to decision making. So what should be the actual limit for this stakeholder consultation committee advice? Because now the regulation also requires that if the liquidator differs from the decision of the SEC, the liquidator is required to record the reason behind the same. Then within a given timeline, the same has to be reported to the IBBI as well. So whether the stakeholder consultation committee is right, should be advisory only, or should be the extent should move towards the decision-making rights as well. The next area which potentially we have highlighted is that the creditors lose their last chance to be the masters of the process by not agreeing to the resolution. So in our view, that once the resolution plan is approved, or once the resolution plan is not approved and the company goes into liquidation, on that part itself, the right should be completely in the hand of the liquidator. And accordingly, the SEC is right. The stakeholder consultation committee, as a nomenclature says, consultation. So this should be limited to consultation and should not go beyond that. I would like to have the views of the other insolvency professionals as to, based on their practical experience, what experience they have faced, because the regulation also requires the changes to be made in the stakeholder consultation committee in terms of the changes that has been introduced later on, even if the respective insolvency professionals have already constituted the stakeholder consultation committee in terms of the erstwhile liquidation regulation as existed prior to this amendment. So I'd like to have a view of the respective insolvency professionals members as to what issues they have faced while having a meeting of this stakeholder consultation committee, or while having any amendment in the constitution of stakeholder consultation committee.
Good afternoon, ma'am. I am Santana Lakshmi, insolvency professional from Chennai. I would like to share my experience with regard to stakeholders consultation committee. Here in an assignment where I am the liquidator, I've constituted a consultation committee. I felt some clarity requires in terms of government claims, and where they have more than one unit. The corporate debtor is having more than one unit. So, and they have different workers, union, employees, association and all. So if we choose only one person as a representative, others, they are feeling offended, they are aggrieved. And as far as the government claims are concerned, there are various departments for GST, income tax, ESI, EPF. So various departments are there. Like, whom should be chosen as an authorized representative for the SEC? That area was gray area. I couldn't understand. So what I did in my liquidation, almost it is in the verge of completion. So I have chosen one representative from all the departments. I have invited everyone and made them participate in the SEC meetings. And as far as the voting is concerned, they have just declined. They have not voted in favor or against the resolution. So that's how it happened. And as far as the operational creditors are concerned, the trade creditors, there were so many operational creditors. So the highest claimant have chosen as authorized representative in the meetings. So it is their duty to inform the other operational creditors from their end, but they themselves are not satisfied. They ask so many questions, and they are asking, why should we escalate the things to the other things? We are concerned only about our claim. If whether our claim will be answered or not, that itself is a question mark. So as per the priority, operational creditor is not given top priority. So even when we are not able to answer their claim, then how we can expect their cooperation to escalate the things to the other operational creditor to act as authorized representative? These kind of challenges I faced, and they also did not vote in favor or against the resolution. They
just have correctly pointed out this lacuna in the liquidation regulation as to the liquidation regulation provides about the constitution of this SEC, and regarding the respective participation by the respective group of creditors, it says that it has to be decided by them. So who will conduct the meeting and how the representation has to be decided? This part is not clear currently in the liquidation regulation. Is there any
important point Santana Lakshmi madam made out is that the operational creditors who have very faint chance of any recovery at all, why would they be spending good time for money which is already sunk? Because they don't see a chance of recovery at all. So we are expecting them to be collaborating in a decision-making process where they're unlikely to recover anything at all. So is it not therefore defying the whole objective of asking someone to contribute and collaborate on a collective decision-making process where you have no monetary interest? I think that's the point that she's, and I think Santana Lakshmi madam, for workmen, you mentioned about different units and different workers. So eventually, how did you resolve this?
Fortunately, one unit was closed long back. It is some 5-7 years prior to CARP. So I have no opportunity to entertain their claims. according to the IBC regulations, were not going to make their payments. There's some salary dues, everything time barred. So I have not included anyone in the SEC, and I have one active unit was there. From that, I have entertained one authorized representative to represent all the other workers.
In fact, that's easier in case of workmen because mostly they have trade unions and the union will be able to select a representative. I mean, there is an internal unity among the workers because they have a union. But Santana Lakshmi Madam's point about...
In case of one unit, the problem doesn't arise.
True.
In
Correct.
case
The
of
multiple
more than
units,
one unit, everyone wants to represent their own trade union and their own unit.
Yes, that's perfectly right. And Barsha, later on, you can probably also flag a question which arises from here. She just mentioned that the workmen, probably the unit was closed more than, let's say, 2 years before liquidation. Therefore, there were not workmen dues over the last 2 years, and therefore, no scope for filing a claim. But the point which other liquidators have faced, that termination due to liquidation itself is a termination. Therefore, that results into the termination claim, the claim under Industrial Disputes Act on account of termination, and therefore retrenchment compensation might become payable. So whether this issue also others have faced, you can probably, when you come to workmen's dues, you can flag this question. But as it stands, her experience from what I understand from her is, while she is on the verge of completion of the liquidation, but probably dealing with this multi-dimensional, multi-stakeholder SEC with people whose interests are not aligned at all, has not been a very fruitful decision-making forum.
So like the ma'am has mentioned regarding workmen's dues, similarly,
Workmen you can take up
will
separately.
happen in case of operational creditors as well.
I'm saying workmen dues you can take up separately, but on the SCC, like she shared experience, others also in case they would like to share their experience of how easy or how uneasy was their, dealing with SCCs.
Sir, may I add one thing here?
Just one quick question before you proceed, Anil sir. If audience can help to maybe just raise hands and say how many of you have actually constituted or how many of you are required to constitute SCCs and therefore actually constituted SCCs. If people can just help by raising hands, so we actually know how many people here have actually had the necessity to constitute SCCs, because there are some liquidations which are prior to 2019. One hand is going up. Anil sir, you also have an SCC experience?
No, sir, but I can tell academically that
Sure.
The SECs have never done any value addition to the liquidation process.
Thanks
Rather,
for
they
saying
contribute
that,
to the
sir.
delay
You're
of
right.
the...
Just give us a second to just come to you. We just got 3 hands going up. Just 3 people out of 329 who have constituted SCCs. So are we saying that all the remaining are very old liquidators and may not be needed, may not be required to consider SCCs, or 4? Or maybe I think I should have actually asked how many of you are not listening, please raise hands. That would have probably been better. Anyways. Okay, I think we have 4 of 3 participants have raised hands. Each of these 3 people have raised hands and therefore constituted SCCs kindly contribute to the discussions. That would be greatly helpful. Others also, in case you slowly realize that you also wanted to raise hands and have not done so far, you can raise it later. Anil said you can continue, and I think we'd like to hear from the remaining 3 people, Mr. Devdas Reddy, Mr. Sandeep Goel, and Mr. Suresh Chandra also, Mr. Abhijit Jain also. So others may probably also kindly contribute, but Anil sir, please continue.
Saying is that, this Constitution of Stakeholders Committee has got no value addition to the liquidation process. Rather, it delays, so it should be like normal COC, which will help in quick decision making. So rather, it should be Committee of Creditors similar to CIRP process.
Okay, others, would you like to share their experience?
Well, it is only the stakeholders consultation committee. How do they come and vote?
Ladies and gentlemen, we request you to keep big bags in the overhead.
Where is the provision for them to vote?
Barsha, you're leading it now. Please go ahead.
Yes, sir. So, based on the discussion till now that we have, the potential areas that we have highlighted, particular when it comes to constitution of SCC, is first that when the respective creditors are not getting anything, or when we all know that the probability of making payment to the respective creditors or the subsequent creditors are low, is it right to have their participation in the SCC? If it is required to form SCC having participation of all the respective field of creditor, in that case, what should be the voting percentage and how the respective representation will be decided? Who will have the meeting and how this representation has to be decided? So this area has to be clarified or should be clarified by the respective regulatory authority. And then when it comes to power of the the SCC, the Stakeholder Consultation Committee, of course, it should be clarified that the power of consultation committee should be advisory and should not be binding on liquidator at all. So these are the potential areas when it comes to constitution of SCC based on the discussion that we have till now. Moving on to the next concern, which is about claim collation and verification. I'm sure that we all or all the insolvency professionals have faced several issues when it comes to collating the claim and then verifying the claim and then communicating the claim, whether acceptance or rejection of the same to the respective creditors. So what are the practical issues that we face when it comes to acceptance of claim, or when it comes to clarifying as to how the respective creditor should file the claim? And then after getting the details of claim, verification of those claims. So there are issues that we have highlighted based on our experience. First is that there is no power to the liquidator to condone the delay. Hence, the respective creditors have to move to the adjudicating authority to file their application under section 42. And if the delay is condoned, then the liquidators again required to make verification and then confirm or reject, accept or reject the respective claims submitted by the respective creditors. So should the power be given to the liquidator? Should the liquidator be empowered to condone such kind of delays? Then if
even Barsha, I want to say something.
Yes, sir. Yes.
Rather, in many cases, department or some financial creditor file the claims beyond the prescribed time period, and we did not accept the claims. The creditor went to NCLT. NCLT reprimand the liquidator and asked in which provision, under which provision you refuse to entertain the delayed claims.
So, sir, yes.
NCLT has mentioned that you don't have any power to refuse the acceptance of claim if it is within the substantial time period. So, but there is no way define what is the meaning of substantial time period. So in that way, what should the liquidator do?
Absolutely, sir. And then again, the concern is that till what time the claim should be admitted, because it has been seen that the liquidation process continues for a period of 4 year, 5 year, in view of the pending litigation, and liquidator continues to receive the claim. So
yeah, but I could not understand why the NCLT or adjudicating authority, whosoever it may be, or the IBBI does not prescribe the maximum time limit for either for any government claims or for any home buyers claims, whatsoever it may be. There must be a specified timeline. Beyond that, liquidator cannot accept, or nor the adjudicating authority can say that liquidator has to admit this claim.
Rightly
So lot of litigations are going on in NCLT only due to the delayed submission of the claim. So what's the use if it is picture clear in the regulations or in the act itself? Then unnecessary litigation can be avoided.
Absolutely, sir.
but
Absolutely.
Pankaj, I feel that this timeline of 30 days should be increased to 60 or 75 days, and that should be the maximum. After that, no claim whatsoever. Maybe
No,
from government or
Anilji,
from
like in CIRP, maximum timeline for financial creditor has been prescribed for 90 days under regulations. So though it is for 7 days to file the claim, but for financial creditor, it has been prescribed that they can file their claim within 90 days of the CIRP.
Same should be done here. After 90 days or whatever time, there should be no entertainment of the claim.
Yes.
Whatsoever.
But NCLT doesn't adhere to these timelines. No, that is the main issue.
So that's why law should be amended, and then
But it's of no use. It's of no use to amend the regulation unless and until Act has been amended.
Correct. So that's what I'm saying. Act should be also amended. Code.
Yes.
Code
So
and regulation
timeline
both
should be prescribed under the code itself, not the regulation.
Yes, exactly.
no, the 30 days is already there, no?
No, dear, 30 days is there. Abhijit, 30 days is there, but there is
Yes.
no bar for acceptance of beyond 30 days.
It's not mentioned there, but
Yeah,
in
that's why I'm saying in my cases,
Uh.
I refuse to admit the claim beyond 30 days. Then NCLT has asked me under which provision you refuse to take the claim.
right, but in similarly in my case, what has happened is I have rejected the claim, and then the party has moved to NCLT, and NCLT has allowed the condonation.
Yeah, that's they allowed the condonation, but in 2 cases, same judge has asked why you did not admit that. See, they are judges. We cannot do anything. They can speak any word.
No, this is wonderful thing then. We can
That's
always,
why I'm
if
saying
there is
that,
no
that's why I'm
bar,
saying-
Liquidator does not have adjudicative powers, so we cannot condone. We cannot
see,
take in hand the
that's
That's
adjudicative
true,
authority.
that's true. But judge is asking under which provision you refused.
To say only the same regulation within 30 days only will be able to accept the claim.
Obviously, but we cannot say anything, any word.
so
That is the main
it
issue.
means-
If it is prescribed, if it is properly prescribed under the act itself, under the code itself, beyond 70 days, no claim shall be admitted by the liquidator. Like under CIRP, regulation provides for acceptance of financial creditor claim till 90 days.
Sir, even 90 days after also, they are going for NCLT and getting the condemnation.
Yeah, they are going.
Okay, 90 days is only prescribed, but actually, even after 90 days also, NCLT is condemned.
Sir, question is, these timelines are under the regulation, not under the act.
Yes.
So this active participation of members clearly gives this hint that all the insolvency professionals are facing this issue of condonation of delay of claim, and there should be a timeline, of course, because the regulation requires the liquidator to make the newspaper advertisement, then make publication on the website of IBBI, and then have a publication on the website of corporate debtor and as well as on the website of the liquidator, if any. So all the potential
Barsha,
areas
yeah,
liquid is required to make the announcement that the company is under liquidation.
Here, one more point comes. Under the code and regulation, it is mentioned that we have to publish for the widely circulated newspaper. So there is no definition provided for the widely circulated newspaper. In one of the home buyer cases, we is published under at the registered office address, we publish at the site address. But home buyer resides all over India or beyond the limit of India. So now judge is asked why you did not publish in pan India basis. So this, I think IBBI has to convey these things to judges also.
Then again, sir, the second move towards this delayed claim or submission of claim is that it has been seen that the government dues, when it comes to specifically income tax or GST, they don't submit their claim particularly. So how to treat those claims? Because for workmen, it is specifically provided in the regulation itself that the liquidator has, if workman has not submitted their claim separately, in that case, the liquidator is required to have the claim from the books and records of the corporate debtor. So,
And the second thing, income tax exclusively, in my case, 2014 onwards, company is not operating. Income tax is writing this is the income tax assessment. And the suspended director, they are not appealed or anything. That amount goes to 490 crores. Company is not operating. They are not doing last 8 years, 9 years onwards. Assessment, they are doing whatever manner they want to include the interest penalties, all those things as per the act. They are charging 490 crores. Even security creditors who are given the loan bank, they will not get hardly 20 crores. And now this person will sit as a security creditor. It's really, we are not able to deny any assessment orders also. There is no limitation of even 1,000 crores also we need to accept.
And in that case, if the CD is not cooperating, if the
Sir,
cases are pending and CD is not cooperating, how will you defend the case?
Yes, CD is not cooperating, and even if you go and file the section 19, it will take 2-3 months for the please they cooperate to RP. Even though after that they will not cooperate, then we need to file the content application. Meanwhile, CIRP period will go over. And what is the punishment? We have not seen any punishment, and happily they are enjoying and attending the meeting, eating snacks and going back without supporting anything.
Nothing is happening. No action on the CDs or defaulting directors. Nothing is happening. So
and under section 45, 50, 66, we are filing these transactions as per the IBBI regulation timeline. I have not seen even one suspended director serious penalty on those applications.
No, Mr. Murli, you have to file application to IBBI under section 70 in this case. Prosecution, the NCLT does not have any prosecution power. Prosecution shall be done through the special court.
Not prosecution, sir. I am saying on the application filed against the 4350, application before the NCLT.
Sir,
Right.
again, prosecution has to be recommended by NCLT to IBBI.
No, Madhusudanji, no. NCLT doesn't have any power.
Okay.
We have to file application with IBBI, and IBBI will file the case with special court.
Sir,
So then
today-
every 19-2 we have to do simultaneously NCLT as well as the special bench के लिए, special court के लिए IBBI.
IBBI.
Correct? Is it
Under
correct?
section, no, you have to see whether what happened in your 19-2 case. If within 1 month it does not resolve, then under section 70 you can file immediately with IBBI. Then it is the duty of the IBBI to file that matter with the special court. So onus on the IP will be finished.
So same thing we can do in liquidation also, sir.
Yeah, same thing you can do.
This section 70 is CARP regulation.
Section 70. It's the penalty prosecution. So it's nowhere it's applicable for CRP as well as for liquidator.
So even the role of RP is over. Once the matter is referred to IBBI, IBBI will be taking up with special courts, na?
Yes.
Then there is no role of RP.
No role of IP.
so is there any precedent?
Yeah, I have filed a case under section 70 in the history of IBBI. My matter was the first case, and IBBI has filed the case in special court of Kanpur, district court Kanpur.
What is the resultant effect, sir?
I am not changing
Any
that.
outputs?
I am not changing that because that is not my baby now.
Yeah, even I filed, and that is not because we don't have to follow.
Yes.
Then who bears the cost?
I think NCLT from
IBBI will be.
IBBI will be doing, madam.
Okay.
I think
All these
NCLT
concern as to who should bear the cost and how the procedure should be, these things also requires attention, and should be necessary amendment should be made in the liquidation regulations so as to provide clarity to all as to what should be the procedure when it comes to these kind of claims. coming to the next issue.
Ma'am,
that we have-
the last question here, claim at commencement of CIRP will not be the same as that of the liquidation commencement date. It is actually when this during the CIRP, the workman claim 2 years prior to the CIRP commencement will be admitted. Now it took some 2-3 years for the company to go into the liquidation. After the distribution commences, so we will see the distribution as per section 53 waterfall mechanism. Now we have to take only 2 years prior to the liquidation commencement date. So those claims which were admitted during CRP, what happened to the same claim during liquidation? Can we
Absolutely,
reject
ma'am.
those claims?
So this is the second issue that we have also highlighted, is that what the liquidation regulation now requires the liquidator to accept the claim if the claim is submitted during CIRP but not submitted during liquidation process.
Even if it is prior to the 24 months and 12 months as per the section 53,
Yes.
we have to admit.
Yes. So say suppose the liquidation regulation, the liquidation process the resolution process itself has taken 2 years to complete. The order for liquidation is reserved for order for say suppose 2-3 months, given the burden of NCLT, and then the liquidation process starts. As at the commencement of liquidation or upon the commencement of liquidation, the respective claimant or the stakeholder has not submitted any claim, given this regulation, the regulation which specifically requires that liquidator is required to admit the claim submitted during CIRP period if no fresh calculation, no fresh claim has been filed during liquidation process. So whether the liquidator is required to count the claim till the liquidation commencement date, the claim should be limited to the CIRP period only, and what will be the fate of the respective creditor, whether the respective creditor will have right to modify the claim at the subsequent stage as well. Say suppose if a creditor is not confirming at the beginning of the liquidation process, but comes say suppose after 2 years that I have to revise my claim. So this will burden the liquidator with this verification of claim task. So this is also not provided as to till what date and how the claim submitted during CIRP period should be accepted by the liquidator. So
And
this is
one
also
point of time, the company is also closed and no, it is not operational between CIRP and liquidation. So now how we have to calculate the claims and liabilities, so those things are very confusing actually.
Even the format of the form is also different. The format of the form for CIRP and liquidation, both are different.
okay. Coming to the next concern with respect to claims is that the clarification is also required with respect to claim which are with respect to verification of claim of secured creditors. Mr. Kothari has already deliberated a bit on this, that given the Rainbow Papers ruling, now the government is claiming towards the VAT dues and claiming themselves as a secured creditor. So what is to be done? Say suppose the liquidation process is almost at its verge of closing and only the litigations are pending. The realization has already been done and the distribution has also, substantial part has also been distributed. Now when the respective government is coming, giving this citation of Rainbow Paper ruling, claiming themselves to be a secured creditor, then what should be done by the respective liquidator? How this claim should be verified or admitted by the liquidator, and how to treat this kind of claim? Because when it comes to secured creditor, there has to be a security. Where are the security? Where is the security interest? Where are the details of security? So these concerns are there, and how to treat the claim when it comes to claim of government, and that too when the same has been established by Supreme Court ruling, requires attention of the regulators and requires clarification for the insolvency professionals. I'd like to invite views of other insolvency professionals with respect to claim, receipt of claim, non-receipt of claim, delayed submission or verification of claim, whatsoever they have during based on the practical experience that they have.
Ma'am, may I ask a question, please?
Yes, yes, yes.
Ma'am, is liquidator have a right to act contrary to the decision taken by the COC with regard to the admission of claim?
Ma'am, can you please just repeat your question once?
Is liquidator have any right to act contrary to the decision taken by COC with regard to the admission of claim? Like if COC has not admitted the claim, then can liquidator can admit that claim?
Yes.
Ma'am, probably you are talking about SCC, not COC.
Yes.
When it comes
Yes,
to liquidation,
SCC.
there is
Madam,
no
SCC.
SCC, ma'am, the regulation currently requires the liquidator to record its
Yeah.
decision if the decision deviates from the decision of this SCC. And then to communicate the same to IBBI. So if say suppose the liquidator has taken on some decision which is contrary to that of the SCC, then the liquidator is required to record the reason behind not being at par with the respective SCC, and then to communicate the same to the IBBI on
On
this.
NCLT.
Yes, sir. Are you saying?
And I think NCLT also we have to inform.
What is the like?
Yes, sir. Yes, NCLT also we have to.
Not only IBBA.
Yes, yes.
Yes.
I think the present amendment holds good and it is good. If we give this power, same COC power to SEC also, they may take some decision and the blaming game will start. So since COC has given the resolution, liquidator can, taken it forward and executed the resolution. So here responsibility rests only with the liquidator because liquidator is taking decision. In case it is varying, contradicting from the SEC, they are recording the resolution, what is the change and justification why he is differing from the stakeholders' views.
So other
So this
stakeholders
is
have.
better, I think. This is fine, I think. This doesn't require any
Is
further
there any
amendment.
locus standi? Is there is any locus standi for in the hands of the stakeholder to file the petition in the High Court against liquidator?
If the SEC is of the view that the decision taken by the liquidator is not correct, then of course anybody is free to move to the litigating forum. So they may of course go to NCLT and make their views as to on what basis they are saying that the decision of liquidator is not correct.
Madam, even SEC can recommend for replacement of a liquidator now.
Yeah.
Oh, actually, we
It
have
is
not
there.
received this type of.
That is why the very first concern that we raised was whether the role of SCC is limited to advisory only or it is slowly moving towards decision making.
Madam, in SEC, whether we have any
Yes,
तो
sir.
मैंने बनाया था अभी तो किसने क्या चेक किया ये कह रहे मैंने चेक
अभी कह रहे कि मैंने जो चेक किया था ना उसके सिस्टम में चेक किया तो वापसी से वही ओरिजिनल फाइल दिख रही है सर मैंने चेक किया ओरिजिनल फाइल आ रही है
ये कैसे तो उसके सिस्टम में खोल के देखे
देख वही सिस्टम अभी ऑन नहीं हुआ सिस्टम दोबारा ऑन करवा के देखता हूं
I'll request the participant to keep themselves muted if they are not staying or not making
Madam,
any submissions here.
SEC, whether we have any voting, we have voting, but 66%, 50%, like that, what are the items? In CRP, we have identified couple of items that required 66% voting like that. In the SEC, is there any like that?
Sorry, sir, you have to repeat yourself, sir.
Madam, what is my query? In
Yes,
the
sir.
COC, CARPs, what are the items required 66% voting? They mentioned clearly. In the same manner, in the liquidation, whether there is any voting rights required 66% or only liquidated decision to go ahead. Because why I am asking, because in my case, we got the income tax department claim. It is occupying a lot of percentage of claim percentage. Most of the government people, they will not participate, or if they participate, they will not cast the voting. Okay, in such circumstances, liquidator will go without a voting percentage at the time of e-auction fixation of the residual price.
So currently, I think there is no such limit provided in the regulation. I'll just check once, sir. Just allow me a second. I'll just check once.
No clarity in the present regulation in liquidation. Which items requires voting 66%?
Madam, it is 31(1)(a). Whatever items that needs to be put before SEC, those items require the consent of the SEC.
Barsha, if you are speaking something, you are on mute. Barsha?
She's referring to the regulations.
She's referring.
She'll come back.
I think they are not mentioned in the liquidation. What are the
Maybe
items required 66%? And what are the items required?
It is there. Murali, it is there.
It is there in regulation 31A, sub-regulation 9. If you
Okay.
see, it says that the advisory which comes from SCC should be at least of 66% representation from the consultation committee.
Madam, what is not there means whether each and every item requires for voting. For example, we are appointing valuers or we are appointing security agencies. Whether everything requires voting or not. That clarity is not there.
This clarity is not there as to on what all item the consultation is required. But
Yeah.
sir, we may take reference from the powers of SCC, which is given just before this particular part. I'll just share.
Madam,
That
they should have mentioned at least what all things form the part of advisory.
Correct.
Advisory includes what?
Whether
If it
every
is
appointment is requires voting or not.
Sir,
that
it is
31
there in 31E,
10,
subsection 1.
3110 very clearly says it is
Subsection
advisory, not
1, it is
binding.
listed.
Everything is advisory, not binding. Am I correct, Barsha?
Yes, sir. So subsection 1, it says as to on what particular part the respective SCC should advise. So the parts are provided, which includes the fees of liquidator, the manner of sale, pre-bid qualification, reserve price, marketing strategy, auction process, then valuation under regulation 35, and the manner in which the preferential transaction or avoidance transaction proceedings, if any, shall be pursued after closure of this process. So these are the potential areas highlighted in the regulation itself that requires the advisory of the SCC. And when there is an advisory from SCC, that requires 66% of vote of the SCC.
Okay, that means for all other cases, that means appointment of security, appointment of any professional like advocates, that does not require approval of SCC. Is it that is the meaning?
So currently from the regulation, it is only coming out that the limit, given the limitation which is provided, it is only coming out that these are the potential areas on which SCC is required to advise. So when the areas are identified, then mostly the advisory should be based on those particular areas only, and the advisory should be at least of 66% representation.
Yeah.
Yes.
But it is pertinent to note that it goes without saying that whatever decision liquidator is taking without the consultation of SCC, he should maintain a contemporaneous record and substantiate why he took that decision at that point of time.
And better to place before the SCC, at least for information purpose, in the next SCC meetings. Otherwise, what will happen? SCC is the main beneficiary of every expenditure or any decision. So tomorrow they will not feel this much expenditure is happened.
And better to maintain in SCC meetings.
Yeah. At least information.
Is there any other experience that anyone would like to share? Here?
Madam, one more point, madam. We have also been receiving from the government saying that there is no requirement of submission of the claim form itself. They can simply by giving a notice of their security as per the Rainbow case law, they are saying that there is no requirement of submitting the claim form. Even this
from PF department.
And in the books also their claim will not be in outstanding. So no one is able to, except God only will know future claims.
Yes, especially EB and property tax panchayat tax and all those things, the revenue department claims, they are not submitting any claim, and it is ever growing. Once the successful bidder comes into place, they have to bear whatever may be the outstanding. In my case, they became very shocked after knowing the outstanding. It is, if they know the outstanding amount earlier, they wouldn't have participated in the auction itself. Then they are blaming the liquidator did not reveal, they have suppressed the facts. So that is how we got into trouble. So there should be some guideline for EB and property tax, I mean revenue claims. They are not submitting claims. Surprisingly, they are coming into picture. Unless their dues are answered, they are not letting the successful bidder to take the possession or take new connection.
In fact, the issues are also faced while taking the possession of land and getting it registered, because sub-registrar, it has also been seen that sub-registrar has also refused to register the name in the name of the acquirer, citing the issue particularly that the liquidator do not have power, or the liquidation regulation does not specifically provide for this. So this is certainly an area that require attention of the regulators.
Even for closing accounts, we have to struggle like anything. 100 times we are writing letters, emails, visiting the banks in person, but still they have confusion. Today I got a query from a bank. In the liquidation regulation, as per the order, your AFA expired on so and so date. So why should whether you have power to close the account? I am telling that AFA is with respect to getting assignment, new assignment. For the ongoing assignment or already passed orders, it has no role to play. Liquidator has power to close the account, accumulate the amount, and operate the account. So kindly do the needful, but they are not understanding. So these things they are asking in your order, liquidation order. It is not clearly mentioned that liquidator has power to close the account, bank account. These are certain small queries. If it is included, some clarity is needed in the regulation, we can finish the liquidation process sooner.
Yes, just my concern is that I have also faced this problem with the banker itself, even in the CRP as well as in the liquidation. Since last 5 years, this act has been activated, but they are not aware about this act. This banking staff, every time they are passing their queries to the legal department, their legal department is also not properly trained, and they are not aware about the IBC Act.
So you are probably talking about secured creditor?
No, I am talking about the
close the account. Bankers, they are sending our request to their legal department. They are not getting clarity in time.
In this happening in CRP as well as the liquidation, the banking the support is not getting to the professionals as they should have. Every time, as the madam just told me, every time they are asking to clarification is required. They are asking to get the order from the NCLT. They get the direction. So it is not possible. It is mentioned in the act itself. Right from the opening the account, for any communication, for closure of account, for transferring funds in the liquidation account. It is a very simple thing. All of accounts has to be closed and all funds has to be come in the liquidation account. So it's even the big banks, nationalized banks.
Can I say something? Hello.
Yes, sir. Yes, sir. Please continue, sir.
Actually, in this matter, I have faced a lot of difficulties in facing banks in opening new accounts, in giving me detail. In that case, the thing which has come to the benefit of mine, that is the circular of IBPI that was issued to me, issued to every IPs, that everyone should cooperate with the IP. So in that case, at the last attempt, before going to NCLT, I usually use this circular that if you will not cooperate with me, please see this circular. You are violating the court order, and also you are not cooperating with the public servant. And that has come to me of use. So in many times, so we can use that also. That was
so
my
we understand that there are so many areas when it comes to acceptance and verification of claim. However, given that today's timeline for this webinar, we have to move a bit faster, and we will take these concerns to, we like to take all these concerns to the IBBI so that necessary resolution can be made by the IBBI. So I'll just quickly go to the next segment regarding tax dues and all. I'll cover in the subsequent session, which is on 12th. So before that, this terms and condition of sale, I'll just quickly cover. So when it comes to terms and conditions of sale, Schedule 1 provides for the terms and conditions of sale as to what should be the terms and conditions. However, there are several lacunas in the terms and conditions that were also highlighted by Mr. Kothari while deliberating. That first issue is that the power of the liquidator with respect to drafting or with respect to making these terms and conditions are not very clear. When it comes to inclusion of forfeiture of the EMD, so this forfeiture of EMD part is not provided as to and which is ultimately we can say that is allowing random participation of the bidders, that they are just walking in, they are participating in auction, and later on they are not concluding the sale and they want their EMD back. The amount which has been submitted, they want that amount back. So given that there is no particular provision with respect to the forfeiture right of the liquidator, so this forfeiture right should be clear in the these actions to be taken by the liquidator in case of non-completion of sale or the contractual breach done by the respective acquirer. This should be clarified in the terms and conditions of sale. And the other issue, as I said, is about contractual application, that the EOI, the expression of interest or the invitation documents, once confirmed by the respective participant, that becomes a contract and should be binding on the respective acquirer so that the sale can be concluded in a given timeline. The next issue that we have highlighted is that to ensure the smooth transition of the assets from the corporate debtor to the acquirer and or the completion of sale. So there should be clarity to the relief available with the respective acquirer, because I'm sure that all of us who have concluded the liquidation process at a certain level have felt this issue, that after completion process, once we file the completion application or dissolution application, as the case may be, the respective acquirer are required to file the application to get the relief from the NCLT. So this, and then till the time the acquirer is not getting the relief, the sale is not treated as concluded. So if the regulation itself will include the respective reliefs which will be available to the acquirer, it will be easier for the liquidator to complete the sale, and it will be easier for the acquirer as well to get the to have the handover of the respective assets of the corporate debtor or the corporate debtor itself in terms of the mode of sale. And the last point when it comes to terms and condition of sale that we have pointed out is that it has been seen that after conclusion of sale, even the liquidation proceeding continues for 2-3 years only because of the pending proceeding. So kindly mute yourself, sir. So it has been seen that even after conclusion of sale, the liquidation proceeding continues for 2-3 years because of the pending proceeding. So should there be a timeline for this conclusion of this kind of proceeding for the matters for which sale has been concluded? So these are the potential areas that we have highlighted when it comes to terms and conditions of sale. I'll request the respective participant to give their views as to what issues we have faced when it comes to terms and conditions of sale.
Barsha, one more issue comes. At the time of sale of the assets, liquidator has to take the GST registration, new GST registration. So after selling the assets, when he filed for closure of the GST registration, at that time GST department took so much time. So there must be some guidelines for the GST department. If the liquidator takes the new GST registration for the selling of the assets, in that case, registration shall deem to be closed as and when the intimated by the liquidator. Otherwise, they make the assessment, final assessment and all, it will take around 1 to 2 years.
Right, sir. Right, sir. Is there any other
Madam,
views,
madam, one more
any
thing.
issues? Yes, sir. Yes, sir.
Once auction may sale is completed and total payment received on or before 30 days or 90 days, once sale certificate is given, handing over of assets will be completed. Generally, we are doing. Everybody is doing. Once anybody paid, then automatically sale certificate they are taking and handing over of assets they are taking. However, as you told, NCLT for passing the immunities, sometimes it is taking months and years also. So if you say till NCLT order is received for the immunities, so the sale is not concluded, the CIRP cost will increase drastically. One more problem, what is the thing is, when disbursement is concluded, we supposed to file the liquidation process application, closure application also. We can't keep the bank account till going concern immunities order is passed by the NCLT. We supposed to receive the realization and distribute the amount. We immediately has to file the liquidation closure process. So sale certificate is issued and handing over is completed. The getting the immunities and doing the process with NCLT is completely responsibility of the buyer. That should not be linked with the conclusion of the sale. I hope I have clear, because
which is
the
correct,
basic,
sir. But again, the thing is that the person who's acquiring the assets, if the person is not getting, you are just simply making the sale certificate. However, the person is not getting the hold of the respective asset that you are transferring and has to move to NCLT with the respective application to get their rights on that. Then, of course, we have to see their concerns as well. And that is why the clarity, of course, is needed
madam,
in the
that is not
regulation.
practically possible. Whatever you are saying, why it is not possible is, there is a regulation stating that once amount is realized, we supposed to disburse the total amount within 90 days only. We can't keep for future ke liye the total disbursement pending. That regulation you have to amend in that situation. Disbursement should not be taken till the conclusion of immunities IA karke, which is not practically correct. Moreover, we are giving sale certificate, handing over of assets we are giving, and original documents also we are giving, just immunities. That is change of the board of directors, share capital reduction and allotment of the shares. That is only, which is a very nominal thing, and which the buyer supposed to act immediately and he has to get it. Otherwise, what will happen, madam? We saw a couple of cases, leased land will be there. The buyer will buy. When buyer immunities IA is filed 2 years, 3 years also, he will not get immunities. Whatever reason, even intentionally buyer may delay the process. When we have handed over, sale certificate is given, he can do all the preliminary exercise and he is supposed to do that one. Otherwise, you amend that regulation. Disbursement should not be happen till the conclusion of immunities IA karke. Otherwise, there is a clash will come.
Correct, sir. Correct.
No,
If the
no, but-
regulation itself will provide the necessary relief to be given to the acquirer, in that case, these issues can be somehow.
I
to
agree.
some
I
extent
agree.
Can be.
If liquidation itself is provides, that means regulation itself is provides whoever purchased the company as a going concern, then liquidator letter itself is sufficient for change of directors, change of shareholders, standard reliefs. Then I agree. Otherwise, madam, if you say sale will not conclude till the NCLT passes the order for immunities, then this regulation will violate. 90 days
No,
I
sir.
cannot disburse.
Sir, how can I say this, that till the time NCLT is taking decision, the sale should not be treated as concluded.
Oh.
Given the current burden of NCLT, we all have seen that one single matter takes at least a year to get concluded. And when it comes
yes,
to
ma'am.
sale and the respective distribution from the realization, then the liquidation process, the very purpose behind this liquidation process or the very agenda behind introduction of this IBC will get infructuous.
influctuals and bankers also beneficiaries. Why should wait after collection also 1 year, 2 years, couple of months?
No, if there are the cases filed even after, see, when the sale is concluded, when can we say a sale is concluded in liquidation? On by giving the physical delivery of the asset also. And if there is some embargo or some cases pending, or say there is a dispute with the workers or other agencies who are not allowing to lift the material what you have sold through liquidation, then we can't say the sale is concluded, and we can't use the funds to distribute. Tomorrow it may get reversed also.
So probably these are the areas that require the attention of regulators. Coming
Hello,
to
ma'am.
Yes, sir. Yes, sir. Please.
May I speak? Yes. I'm talking about the sale of assets in case of, in a scenario other than going concern. In the case of other than going concern, if the liquidator is selling the assets by way of auction, only the assets of the company like land and building, plant and machinery and these things in the lot, other than as a going concern, an acquirer, what precaution he should keep in mind that we should get through from all these problems of getting the approval or some hurdles from the NCLT or some litigation and other things. Should the liquidator handing over the letter to the sale letter to the acquirer and handing over the possession is sufficient in that case?
Yes, yes. Yes, sir.
Is there any obligation on the liquidator that the liquidator cannot withhold the other matters related to that particular property, like handing over the title deeds, clearing from the bank the charges on the assets, dues, everything? So I think there will be a different scenario from an ongoing concern sale and other than ongoing concern sale by the liquidator.
Absolutely, sir. Absolutely. This is correct. Yes. Is there any other views, any other experiences?
Ma'am, as far as the charge is concerned, the charge is created with the MCA or ROC. Once we are liquidating the company, assets are sold, anyway, we are going to dissolve the company. What about filing of CH4, form CH4? It is not serving any purpose for filing these kind of forms.
No, you don't require to file any form. Under
No
liquidation.
need to file it, sir.
No need.
Because we are trying
just uploading of resolution order by INC 28, it suffice the purpose.
Thank you
so much. By way of one form, na, sir. The court order we need to file by way of INC 28 or something.
Yes, INC 28. That's why I'm saying now.
For dissolution or liquidation process.
Yes, sir. The order of the respective NCLT is required to be filed with ROC with a respective clarification note giving these highlights as to what all changes are required to be made in the NCA portal. Of course, with respect to these charges, the regulator is not.
No, we don't require to mention anything. It's the duty of the ROC.
No note is required.
Not required. It's the duty of the ROC. Just we have to upload the order.
In many cases, sir, it has been seen that the ROC is not making changes. Even
no,
you
that's
might have also faced this issue.
That's their duty. That's their duty, Barsha. That's not the duty of liquidator.
So, in fact, you might also have faced this issue that even after the company is going into CIRP or liquidation or voluntary liquidation, as the case may be, the status of the company is not getting changed.
Ma'am, it's not in our hand. It's not in our hand. Once we have given the intimation to ROC, onus is shifted to on ROC.
Absolutely, sir. The onus is on ROC, which is correct.
This is
filing INC 28. Sorry to interrupt. After filing INC 28, everything we can do is to file through GNL 2 form. And not more than that. Because if we will continue to take more burden, it is already burdensome. This
no, nothing else.
So they are changing also. They are changing, but they are taking time.
Sometimes it's taking some little bit later.
Yeah.
And what about if ED attachment in the properties during the liquidation? The ED attachment, whether we are able to go forward and subject to ED attachment, whether we are able to go forward for the e-auction, sir?
No. Then first of all, you have to clear the attachment from the NCLT.
Sorry, could you please repeat, sir?
You have to clear the attachment from NCLT. You have to file application for de-attachment.
Okay, then
It may not be required, now, sir. It may not be required, now, sir. As is
It is not. It is not required. But you know the ED department, na? Unless and until they don't have any direction from the court, they will not comply on your simple letter.
Yes.
Meanwhile, I filed one application. I am the respondent. Financial creditor filed application appeal before the PMLA. Each hearing is taking 4 months or 5 months. And every month I need to incur a lot of expenses to.
No, you don't file. You don't need to file with.
No, I am the respondent. I need to file the counter against the whatever the application I received.
Yeah, parallelly you should file with the NCLT also.
Yes, sir. I filed NCLT one application before. Okay, I am seeking for the e-auction subject to this one and de-attachment of properties before NCLT, and I filed whatever the counter is required before the PMLA also.
In the meantime, you can put the assets on auction, mentioning that it is under the attachment of the ED.
That only, sir. I'm trying.
Yes.
Subject to ED attachment is there, we will go forward with it.
Exactly.
Yes. But yesterday I attended PMLA delay. They point out you don't have a right to go forward like that. But
that's why I'm saying that you have to file application with NCLT. You don't have any locus standi. You don't have any locus standi under PMLA.
Yes, sir. That's the reason I filed before NCLT and the simultaneously PMLA counter also I filed as a liquidator.
Exactly.
But Pankaj ji, if I try to do the sale, declaring that it is subject to a ED attachment, will there be any bidders?
Sir, we will mention the bidders should buy irrespective of the outcome of the so and so cases.
There is chances of value reduction, sir. If there is no ED attachment, means maximization value is possible. If ED attachment subject like that means the value
we used to use the word as it is, where it is, with, with no recourse basis.
Yes, as is, where is basis, no recourse.
Currently, that is the mode that all the liquidators are using to sell the assets on as is, where is, whatever there is basis, giving the respective disclaimer with respect to the assets that they are selling, because the liquidator is providing the information to the best of the informations are available with the liquidator and cannot provide something which is beyond the hand of liquidator.
Yeah, Pankaj ji, my question is whether the title can be transferred while the attachment of it is there.
Subject to outcome.
Outcome may take 1 to 3 years.
No. If it is if you file the application with NCLT, it will not take so much time.
Sir, NCLT is not entertaining ED
there is a fight.
Yes,
there is a fight between PMLA and NCLT. Who is going to be who is going to have the upper hand?
No, sir. A lot of matter is Supreme Court had decided in this way. And now regulation
NCLT के फेवर में तो कोई डिसाइड नहीं, मतलब आईबीसी के फेवर में तो डिसाइड नहीं हुआ, वो तो बीएमएलए के फेवर में डिसाइड हुआ।
उसके अंदर एक कमेटी बना है और उसमें लिक्विडेटर will chair the committee.
In many instances, NCLT has given relief for assets which have been seized by PMLA enforcement. So in many cases, you can find it.
So that we can discuss because it is not, this question is not for this forum.
All right. Yes.
I think we should move to the next concern.
Yeah, Barsha.
So this is regarding the treatment of avoidance proceedings. What should be the treatment of avoidance proceedings? As currently, we all know that in the discussion paper, it was provided that this should be decided by the SCC as to how this proceeding should be taken forward. However, ultimately, when the changes came into the liquidation regulation, it provides the burden, or it throws the burden on the respective liquidator to decide, of course, with the consultation of SCC as to how these proceedings will be taken forward. So there are concerns as to once the liquidator has completed the liquidation process or the liquidation process is complete and pending the avoidance transaction proceedings, then how and what manner these proceedings will be taken forward, who will take forward this liquidation, this avoidance proceedings. If the liquidator is required to continue with this, then who will pay the fees of the liquidator? Given that the fees of the liquidator currently, which is provided, is based on the realization and distribution part, if not specifically decided by SEC. And once the sale process is complete and distribution is made by the liquidator, then there will be no area of any further payment to the liquidator. Then how the fees of the liquidator will be paid for the subsequent years during which this avoidance proceeding will continue. So this is one of the concerns when it comes to avoidance proceedings, because it has also been seen that when it comes to application relating to avoidance proceedings, these are at the least priority before the respective NCLT benches and are taking longer than usual time to get complete. So how these proceedings will be taken forward? So this is one of the areas of concern, and I would like to invite the views of the respective professionals on this.
Madam Garu, it is better liquidator should continue in spite of liquidation process has been closed. The cost of the each avoidance applications ke liye, rough estimation should be included in the liquidation cost itself, and that has to be paid to the liquidator, because liquidator only found all these avoidance of transactions properly couple of years, 1-2 years may. So he only better to continue, and if he continued, the cost of the future proceedings should be estimated and should be given to liquidator, and there should be cost of liquidation cost. That is my opinion.
Sir, liquidation cost is deducted prior to making distribution to the respective stakeholders.
Correct.
And once
Correct.
the distribution is made, that is a liquidation cost is deducted first, and thereafter the respective distribution has been done. And
Yes, madam.
the liquidator is also required to file this closure of bank account details along with the dissolution application. And the liquidation and the regulation permits the liquidator to file the dissolution application in case even if the avoidance proceeding is pending.
That's
so
correct.
if say suppose the dissolution is done, however the avoidance proceeding is pending, then on what basis the liquidator is required to make estimation as to what will be the cost?
What is my point is, for example, liquidators are supposed to maintain the books of accounts for 8 years. So obviously, whether liquidator will maintain or any IP entity will maintain, get the estimation for 8 years for that work ke liye, and include in the liquidation cost and get the approval of SEC and pay before disbursement itself, because it is form part of liquidation cost. Similarly, avoidance of applications also before completing the total disbursement. Any liquidator and SEC will came to know how many avoidance of applications is there, tentatively how much time will take, whether liquidator will continue or any IP entity will continue those avoidance of applications. Better to assign some value or costing and consider that is as a liquidation cost by definition itself, changing the definition itself, and smooth closure will happen.
No, Mr. Rao, we can do one more thing.
Tell me, sir.
Under provision of liquidation regulations, there is one clause where you can, a liquidator can sell the not readily realizable assets to third person.
Correct.
Okay, whatever is your undervalued transaction, whatever it may be, do a valuation of that and sold that property. So that your burden will be finished. You don't need to bother all these things.
Sir, that is also another alternative. Many IPs also doing same exercise. NR assets sell.
Yes.
Sometimes if that is not able to sell, or SEC decided that we will recover more, not to.
So better transfer it to the SEC. Transfer it to the digital banks who don't give the permission for selling.
Yes, sir. Next alternative.
Yes, why to take the burden of all these things?
Yes, sir. Correct.
And what in case the SEC doesn't want to take, or the
so then you
want to take this burden?
Sir, we have to be some strong.
Hey,
We have to
Pankaj,
be a
I'm sorry,
strong man.
Pankaj, can you just
Yes.
repeat what is your suggestion? That
Sir?
avoidance monies, we sell the avoidance monies to an interested IPE.
Yes, not IPE, to any bidder.
Any bidder, okay. It may be a
To
law
any
firm
person
or
who's interested in acquiring these kinds of not readily realizable assets.
And a lot of discount will.
Huge discount, huge discount.
And justification little, as you correctly told, valuation we have to get.
Yes, we had, obviously we had to make the valuation for financial assets, na?
Avoidance of transactions.
Yes.
Sir, one question. Sir, one question from my side.
See, one suggestion is all the sale proceeds, or receipts from the avoidance transactions can be deposited into the government fund also.
No. Who will allow you to?
How
Who
can
will
you
allow
submit
you to
this to
deposit in
government
government
funds?
account, Anilji? Who
No,
will
sir,
allow?
one more alternative is there. If the SEC, they don't want to pursue these matters, then we can ask successful bidder who has acquired this company. We can ask them to, because they are also pursue and they can appoint the advocates.
No. We have to sell those assets. We cannot give it to free to any successful bidder, man.
That also has to be valued and reserve price.
Yes. Certainly, it has to be valued.
Yes, whatever assets you are selling pursuant to the liquidation regulation, ma'am, that requires valuation. And pursuant to
After
valuation,
valuation.
after getting the reserve price, you have to sell the assets. So nothing can be sold at free of cost without having the valuation.
If the valuation is zero, then what should be the position?
Then you can ask
acquirer
us.
may or may not be interested to have these kinds of assets, because certainly the avoidance transaction proceeding that you are finding out is the lacuna of the erstwhile or the acts done by the erstwhile management in the management and affairs of the company. So based on that, we are finding out those issues in the avoidance transaction issues.
In that case, if the liquidation value is zero, in that case, SEC can easily give you the permission for any amount which you want to put under option.
But Pankaj ji,
in that case, sir, reserve price can be fixed at the bare minimum after consultation with SEC members.
Yes, certainly. Onus is not on you now, onus is on valuer.
No, even in buffet transaction, it is the allegation which we make over the suspended directors or the erstwhile promoters. It is not established. The cases
Let
are
them do,
filed.
sir. Let them do.
No, but
onus is not on you. Onus is on the valuer who has given the valuation.
No. In buffet transaction, we have identified certain value, like certain amount that this has been, but we are feeling that these are the traditional preferred transactions.
Right.
These are not established or any order is passed against that application.
Right.
And even the stakeholder doesn't want to take this. NRRA will try to sell. Nobody came forward to take it. What will do this application now?
So, Barsha, there is a requirement of amend this. It has to be included in the regulations for clarity.
Yes, it's better to have a clarity in the regulation itself.
More clarity.
Because people are, of course, proceeding ahead currently based on their practical experience or based on the best that they think in the respective liquidation proceedings.
Exactly.
Suitable. But the clarification, of course, is required in this regard in the liquidation regulation itself.
Yes, clarification.
Barsha and Pankaj, one more suggestion is that, this maintenance of records, the period should be reduced to 2 years. After liquidation and dissolution, there's no point keeping the record for 8 years. I think the period should be reduced to 2 years. That is good enough.
We have mentioned under CIRP for 3 years.
3 years.
So in the same way, we can keep it for 3 years under
that can be done. Yeah.
So currently only physical copies are required to be maintained for 3 years and electronic copy for 8 years.
Electronic copy also to be reduced to 3 years.
I have one confusion here regarding the maintenance of records. It is only the record what we have created over the last 2 years as a CRP or under liquidate? Only those records or records pertaining to the company for last 8 years?
No. Only the liquidation or CIRP records. That is mentioned under
got
regulation.
It is clearly provided, sir, as to what all.
Clarity is given in regulations. If we
Yes,
sold
of
the
course.
Only
company
those
as a
registers,
going
no? It
concern.
doesn't mean, it doesn't require the company's document to be kept.
Sir, company documents also we require to maintain. If we have not sold the company as a going concern, if we sold the individual assets, then the liquidators are responsible for maintenance of CDs accounts also, CDs books also, for 3 years and 8 years.
And it does it say.
Sir, it is given in the regulations clearly.
It is
Amended
provided in
regulation.
the regulations, sir, that
Amended
these
regulation.
documents are required
What
to be
exactly
maintained by the
says?
liquidator.
Barsha, what exactly says? Only the certain registers or what is required to be maintained? Only those documents?
All
the documents
corporate debtors records.
Sir, I'll just share the respective part of the liquidation regulation, which
Correct,
says about maintenance of record by the liquidator.
The cost for maintenance of records should be included in the liquidation cost definition. Otherwise, none of the SEC will approve.
నా ఫోన్ చేసుకుంటాను రివ్యూ ఉంటుంది మోస్ట్ ఆఫ్ ద టైం అనుకోండి.
Whether my screen is visible to all?
No.
No,
ma'am.
Barsha, it should be all records. It should be all
Just a
records.
second, sir. Just a second.
Physical as well as, soft, whatever, for not more than 3 years.
Including CDs.
I hope
Including
it is
CDs.
visible to all now.
No visible.
Yeah, now visible, madam.
Barkha, it's regulation 6.2.
It is regulation 45A as well, which provides for preservation of records by the liquidator, which says that the liquidator shall preserve all such records which give a complete account of the liquidation process. So this particularly talks about the liquidation process records. Then coming next, which is point number 2 or clause number 2, which says that without prejudice to the generality of the provisions of subregulation 1, the liquidator shall preserve copies of records relating to or forming the basis of his appointment, handing over of documents, admission, public announcement, etc. So these documents are giving hint of the liquidation process documents only, sir.
If it is there.
You can refer regulation 6.2.
And then regulation 6 is there. Of course, regulation 6 is there, which talks about the registers required to be maintained. Registers and books and accounts, which are required to be maintained by the liquidator.
Yeah, but it doesn't talk about CDs books to be maintained, right?
No, it is there. It is there.
No, CDs book are not required.
How can we, boss? How can we?
Not required to. Only the liquidation process, sir.
Only the CRP and liquidation records are to be
Yes.
maintained.
Otherwise, CDs record for how many years of CD records you will keep for 8 years.
Yes, CDs proceedings may go on in other forum because if PF may go against the directors, PF department, income tax now can go against the directors.
Against the director, they will always go. But CDs
So
books,
this-
if you say.
So CDs records are the responsibility of the directors only.
Yeah, they should keep
So
the
when
record
it
if they
comes to
want.
this regulation, regulation 6, subregulation 2, this says that the liquidator shall maintain the following registers and books as
That
may
is
be
also-
applicable in relation to the liquidation of the
Liquidation
corporate
of the corporate
debtor.
debtor,
This is
not for the.
liquidation of the corporate debtor,
Yes,
and
yes,
not
yes,
the
yes.
the books and records which were maintained by the corporate debtor earlier.
During liquidation, you have to keep, or if you are the RP, then for the CIRP you have to keep, and if you are the liquidator, then only for the liquidation process, these accounts you have to keep.
Only
Sir,
the proceedings
sir,
which pertains
no.
to the liquidation process are the responsibility of the liquidator to maintain.
I think one more provision is there. I am not immediately recollecting. If we sold as a going concern, if we have not sold as a going concern, who has to maintain the CDs records also? One para
No, there is no regulation.
That, okay.
No, Madhu, you are saying is correct. With going concern, without going concern.
Is there? Is there? With going concern, without going concern, if with going concern sale, then CDs accounts should be given to him. Otherwise, liquidator has to maintain.
Kindly share the regulation.
I will just check it, sir.
Sir, we need to include one more clarity, how the mode of disposing the records. See, certain records may be very important and confidential. It should not be given to the public. Those records can be destroyed by firing it. Destroyed in fire, or those other records can be sold to the waste paper mart. So those, what are the records that should be burnt and destroyed? Destroyed or disposed.
You cannot sold those assets to the some kabadi. You have to destroy it.
We have to destroy everything, sir.
Yes.
We cannot sell it to, in the
after 3 years.
Oh my God.
After taking electronic record.
Thank God I didn't sell so far.
What document you are talking about?
I think more and more we are going to have only electronic documents.
Another thing which Madam has rightly pointed out, that the NRRA, if for NRRA the proceedings would not stop. Actually, the provision should be there that if any bidder would come for NRRA or not, the once that has been decided that these assets on avoidable transactions assets or whatever assets have been allotted to NRRA, so the company can go for dissolution, can go for sale as a going concern, so that if afterwards if anything would be recovered, that if any bidder would not come, the amount would be distributed amongst the stakeholders or the prospective bidders. That provision should be there, and by doing that, hello.
Yes, sir, you are audible, sir.
Yes, but by doing that, we can actually increase the pace of the proceedings.
Okay, is there any other views
Yes, one
on
question.
this avoidance transaction process?
Regulation 45 of 45A of 5 and 6. Please open, madam. There is clearly given, if it is sold as a going concern, the corporate debtors books should be handed over to the. Please open regulation 45A of 5 and 6. Or I will read if you want.
Yes, so it says that where the corporate debtor has been sold as a going concern under clause E, the general records of the corporate debtor shall be handed over to the successful buyer, which is otherwise as well, given that the
general records of corporate debtor.
The records of corporate debtor.
Yeah, and 6, please read, madam.
And it says that the record of corporate debtor shall be preserved by the liquidator as per the applicable laws. So what records of the corporate debtor?
As per Income Tax Act.
Records of corporate debtor.
What all records of the corporate debtor should be
Again, what will
preserved?
happen, madam? These records of corporate debtor, we supposed to responsible for ED, CBI. In spite of the liquidation process is closed, we can't tell to CBI, ED, and all these people we don't have records, or we sold, or I am relieved from the order of liquidation process. We have to provide all these records. So if it is sold as a going concern, our responsibility will shift from us to buyer, and buyer simply says, I am not responsible for previous, because we are facing. We shown these provisions to CBI and ED, and we have produced the acknowledgement letters taken from the successful bidder as we handed over the corporate debtors records. And again, what is the general records of corporate debtor is not clearly defined. So authorities will ask each and every record.
So let us understand in this way that the records of corporate debtor or liquidation proceedings that the liquidator is required to preserve can be divided into two parts. One is with respect to the corporate debtor, the liquidator with the records which have been handed over to the liquidator upon commencement of the liquidation process. And the second one is the documents which are required to be prepared by the liquidator during the liquidation process. So when it comes to the records of the corporate debtor, those pertains to the corporate debtors record as was handed over to the liquidator, that as per the current regulation is required to be maintained by the liquidator for a period, for a specific period. And when it comes to the liquidation documents, the documents which were prepared by the liquidator during the process, that specifically has been provided as to what all will be included in the liquidation documents. And for those documents, the regulation currently says that for 3 years, the physical documents are required to be maintained. And for 8 years, the electronic documents are required to be maintained. However, clarity is required as to when it comes to records of the corporate debtor, what all records should be maintained by the liquidator and for what time.
Hey, Barsha, now question arise. Just a minute. Now question arise. Liquidator shall preserve the record of corporate debtor since when? Since the incorporation of the company, or because CBI ED can ask for any document. So since when the record shall be kept by the liquidator?
Sir, that clarity should come, sir. That clarity should be provided in the regulation.
So that clarity is required to that. If the record of corporate debtor, this like the liquidation records has been clarified as to what all documents pertaining to liquidation process is required to be maintained by the liquidator. Similarly, that clarity is also be provided as to when it comes to record of corporate debtor, what all records should be preserved by the liquidator. So it will be easier for the liquidator to maintain.
Since how many number of years? Since how many number of years?
And for the period for which the respective documents are required to be prepared.
Some companies 40 years also will be there.
I think it will increase the liability and responsibility of liquidators and resolution professionals only to ask for what records of the corporate debtors should be kept, because if there would be any proceedings later on by PF, by ED, by PMLA, then the liquidator, after getting discharged from the assignment, will act as a record keeper and will go to PMLA. In that case, I think the thing should be clear that a liquidator or a resolution professional's liability is restricted up to the information shared with him by the management.
That is best. Madam,
but explanation is also there, sir. Could you please look at the explanation in the same section, which says that what does record refer to?
The records referred in this regulation includes records pertaining to the period of liquidation process during which the liquidator acted as such, irrespective of the fact that he did not take up the assignment from the its commencement or continued the assignment till its conclusion. So from the date of CARP commencement.
Yes.
No,
what will happen to the
Barsha,
earlier records? Because
Pankaj,
most of the
Barsha,
time it has been seen that the income tax department or the respective regulatory authorities are coming up with the issues or concerning with the past affairs of the corporate debtor. So what will happen to those documents? How those documents will be preserved?
In that case, the directors would be liable and responsible for
so
providing
those clarity
my
should be
question
there.
is that only. Can we give those kind of records to the director?
Under section 30, under section 33(5), no suit or proceeding can be initiated by or against the corporate debtor.
Absolutely.
So liquidator is concerned with the corporate debtor only. So no department like income tax or GST can initiate any proceeding against the corporate debtor. They can initiate the proceeding against the director. But
so
no
while proceedings, you have correctly mentioned that proceedings cannot be initiated by or against the liquidator. However, you might also have seen this particular part as well, that the regulated, when it comes to liquidation process or after commencement of the liquidation process, all the respective governmental departments are coming to the liquidator only with their concerns. with the respective issues.
That's why now it is clearly mentioned no suit or other legal proceedings. Legal proceedings include even the assessment of the income tax also.
Even if for the matter pertains to the period before the liquidation process.
Yes,
Maybe
yes,
for
yes,
the
yes.
purpose
Even
of
then.
proceeding or continuing with the proceeding of that affairs, the respective regulatory authorities may require documents. So who will maintain the documents?
No, Barsha, when the liquidation had started, so simply liquidator can mention that the liquidation process has started. Now you cannot pass any order against the corporate debtor.
And when the respective department is asking for the documents, sir?
We cannot, because no legal proceeding can be initiated, na?
Sir, initiation of legal proceeding is a separate affair, sir. I am not here talking about the initiation of any proceeding against the liquidator. I am talking about the proceedings against the ex-management based on the documents and affairs. And say, suppose, let us take an example of income tax proceedings only. So when it comes to income tax proceeding prior to the period of liquidation, say, suppose the liquidation process started at on 1st of April 2023. So as on 31st of March 2023, the records or the information or the income tax documents that the respective income tax authorities will require, who will maintain those documents? Because ultimately the income tax authorities are coming to the liquidator asking for those documents.
Yes. Now see, if you are saying an example of that liquidation process start from 1st of April 23, it means that prior to that CIRP period was going on, right? So
yes, sir.
Yeah, for CIRP, RP has asked for the documents from the corporate debtor.
Yes, sir.
So that document has been transferred to the liquidator.
Yes.
So simply for income tax, only 3 years document you have to keep.
So even it has been seen that even after
Pankaj, one more
these
thing.
issues, that the matter that the company is under liquidation and we are with the limited documents as has been handled by the ex.
We can put in this way, we can suggest the ICSI IIT to ask the IBBI to make it clear.
Absolutely, sir. That is what my point is, that the clarification is required so as to reduce the burden of liquidator when it comes to
make it short, we can
issues.
ask for the clarification.
Absolutely.
Pankaj, one more thing, Pankaj and Barsha, that, under the Companies Act, the books of accounts and statutory records are to be maintained for 8 years. So what happens to those records, after for the records under the Companies Act?
No,
So,
sir, Companies Act of after dissolution of the company, there is no locus standi of the ROC.
No, but if there is any income tax proceeding or something, you have to statutorily you are required to maintain these records for 8 years. Huh?
So that is why we are saying here that for this particular requirement, the records of the corporate debtor, what all documents should include in this record of corporate debtor, and for what time this records are required to be maintained should be clarified.
Clarification is required in the law, definitely.
Yes, ma'am.
Ma'am, I want to add one more thing here. According to section 170 of Income Tax Act, if the corporate debtor is liable to pay some tax, it is due, the income tax authority has power to recover it or to sue the directors or promoters of the CD after the dissolution. So anyway, these records would be required for the directors. Why don't we give those records to the directors now before destroying it?
Santaji, no one will take the responsibility.
Who will take the responsibility?
Directors will say we are no more. We are free now.
None of the directors will be ready to have those responsibility or have those documents with them.
Directors'
responsibility. We are not supposed to hand over any documents to them to face the litigation also.
No, that's their headache.
Currently, those areas are still, requires the attention of the regulators, that what will happen. The synchronization is not there between the respective laws, as because the Companies Act requires for a certain period of time to for maintaining the documents. Then again, when it comes to income tax provision, that requires that initiation of proceedings against the ex-directors, which may require records for the past affairs as well. And then this requirement under IBC. So this explanation has to be there.
Barsha, I have a point. I have a point here. Thing is, say, what you are concerned about, what will happen with the, say, once the company gets liquidated or dissolved. What will happen if the department requires any document, if they want to sue case against the, or file any case against the ex-directors? Are we at all concerned with that? Why will we provide any document? Let it be like that.
Yes,
if we are not bothered to maintain, why should we at all maintain?
No, I think
there should not be any question that liquidator or resolution professional would provide the records. We are not record.
Fantastic.
We need only information. We need only information, and yes, as it has been pointed out, that in case of going concern sale, the person who is going to purchase that, in case there would be any future litigation, he may need those records. In that case, those records would be given to them. That a resolution professional or a liquidator would supervise that yes, he has got all these records. But otherwise, we need only informations and documents which are required for CRP or liquidation, not more than that.
Because earlier year period, why will we provide to anybody when we are in
otherwise what will happen that if there would be any notice to the directors from PF department, from GST, from income tax, directors would shift the responsibility to the liquidator, ex-liquidator.
Yes, that is actually happening. That is actually happening.
This is what actually happening, and I am also facing this.
So, of course, there are several points still remaining to discuss. However, we have already crossed the timeline for today's webinar.
That's one point.
Yes,
I want to ask. I want some clarification on NRI assets, sale of NRI assets. In that, I am in a process of not sale. We are assigning the not really realizable assets to the legal pay. So in this case, actually, we are assigning this. We are not actually selling it. They are taking responsibility to distribute the whatever realization in future, in accordance with the section 53 of the Act. They will distribute. And in this case, I will be going to file the early dissolution. I will be not there. They will have all control of realization, whatever it may be. It may be 10%, 15% of the assignment value. After deducting that legal cost, they will get the amount. So who will have control on that, whether they will distribute the amount to the concerned stakeholder in accordance with the section 53 of the Act? Here, the clarification is not there in the Act.
So distribution is still in the hand of liquidator only, to the best of my knowledge. So whatever distribution is required to be made is required to be made by the liquidator.
In this case, we are closing the bank account, no? We are closing the bank account in this, yes.
Practically, on the basis of practical experiences, what the professionals are facing when it comes to selling of these kinds of assets, of course, those are concerns to be raised before the regulators as to how to deal with these kinds of issues when it comes to selling or assignment of this NRRA assets. Of course, these are the potential areas that
if in particular case, if no bidder would come to bid for NRRA. So in that particular case, it needs to be, it is requiring that the proceeding should be should not be stopped. The proceeding should continue, and in that case, there may be one just suggestion that the liquidator, the erstwhile liquidator, may be the head in monitoring the distribution to the stakeholders after liquidation, not more than that. And
Barsha, can we do one thing? Because we have to give the suggestions on the liquidation regulations. So in spite of mixing all the regulation, can we put regulation 1, 2, 3, 4, 5, if anything is change required in regulation 5, if anything change required in regulation 6, any suggestion under regulation 7, for some amendment in regulation 8, can we put in this way so that on every regulation a healthy discussion can be possible and we come out a proper solution for recommendation?
I think, sir, we can do that. That can also be done. Or the
Yes.
specific regulations, there may be regulations which do not require any such amendments. So
Exactly,
those we can
exactly. So
skip.
all regulations will be covered.
Right, sir. Right, sir. So,
One by one, all regulation will be covered.
so over to Nitika, ma'am. I think
Barsha,
we have
ma'am,
already.
I want to ask, can I ask a question? One last
Ma'am,
question.
Shubham ma'am, actually next Wednesday also will be having the similar discussions on liquidation regulations only. So maybe next time you can ask the questions.
Nikita, we can do one thing. Nitika, we can extend the time on next Wednesday so that
Sure, sir.
all regulations will be covered and every participant has their say on that regulation.
Yes, and next Wednesday we'll be covering voluntary liquidation also. So we'll extend the session.
Yes.
That will be fine, sir.
Right. Right, sir. Right, ma'am.
Thank you, Barsha.
Thank you. Thank you, everybody.
Thank you.
Thank you all.
Thank you so much, everyone.
Thank you very much.
Thank you, sir.
Thank you.
Thank you all.
Thanks a lot.
Thank you all.
Thank you, sir. Thank you.
Thank you. Thank you. Thank you all.
Many thanks.